Thanks everyone for coming along. Nice to see a couple of familiar faces from last year. I'm just going to start off by saying last year's legislation changes were big. We had all the sexual harassment changes, we had psychosocial safety, we learned about the positive duty that management now have, and 12 months on, it'll be interesting to maybe when we have the Q&A to see whether how that's kind of landed for you and how you're navigating some of that. It's fair to say the closing loopholes bill that came through in February is massive. It was massive. It covers so many things, most of which don't affect you, which is really nice, right? I mean, it's interesting, when I was kind of preparing for this and some other sessions I've run, I'm thinking, why do they call it closing loopholes? Well, the name actually says it all. And when you then look at the detail of what was in the bill, it is all around, well, there was a loophole there, let's close it. And every little part of it is, there was something not quite right there, and what we're trying to do is close what the legislators saw as a potential problem. So as I talk you through some of the changes, some of them will be as simple as that. And so, in terms of giving you information about what you need to do with this, some of it will be, well, note that, and some of it will be, well, you need to look at your policies and your documents and so forth. So I'll try and navigate through each of them in that way. Some of them will be very brief. At the end, I'm going to give you the list of the things that I don't think apply to you, but if you then have a question about that, then feel free. But it's things like gig economy workers and enterprise agreements and, workplace delegates coming on site and union reps and so forth. So for some of you, maybe that's something, I don't want to gloss over it, but I think for most of you, that's the part that you won't need to know too much about. So the first part was around, let me just make sure I can actually read this with my glasses. So the first one I want to cover off very, very briefly is that there's some changes to small business redundancy. So you would know if you're under 15 people, you're considered a small business. If you had your business or part of your business went through some kind of restructure and you were a large business, and you go through a restructure as a result of insolvency or some sort of transactional change in your business, and you go under that threshold of 15, there's now a close of the loophole to mean that if you made redundancies on the back of that, you'd still be considered a large organisation. So I guess it's like, you can't sort of shed a whole lot of people, sort of go into voluntary administration, make a whole lot of people redundant and not have the obligation to pay them. So it makes sense. Probably won't apply to most of you because it really needs that transaction to have happened, but just something to have on your radar in case it ever was a situation you had to face. That came into play on the 15th of December. This one also probably doesn't have a broad application for you, but I think it's something to really bear in mind if you ever do have a temp workforce, because sometimes a temp can form part of this labour hire sort of definition. So what this close of the loophole is where, I don't know if you're aware of this, but historically there's been situations where different businesses have hired temps through labour hire firms, and the conditions that they've been employed under have been quite different to their other employees. Usually, well, I guess the loophole is trying to close where those conditions have been worse. So what the legislation now does is says that you can't have an arrangement where the people coming through your labour hire firms are actually working under conditions that are not as good as your direct employees. And basically, it's basically mostly around pay, and the Fair Work Commissioner can come in and kind of make a stop on that. Again, probably not going to affect you too much. I'd suspect, if you've got temps in your business, you're probably paying more for them than less. But it's just something to watch. This is, you've got to remember this is legislation for every industry out there, and there's some vulnerable workers that sometimes get caught up in this area. That will come into effect in November. This one obviously affects all of us. Last year we had a big change in legislation around family and domestic violence. I suspect there might be some more coming, watch this space, but certainly the introduction of the 10 days of paid family and domestic violence leave came in. What was added through Close the Loopholes was that it is now considered adverse action if you discriminate against someone who has experienced family or domestic violence. So you make a decision that's detrimental to that person, on the basis of the fact that they've experienced domestic violence, that could potentially be a breach of a general protection. So what you need to do there is, if you've got your workplace policies that cover all your areas of discrimination and adverse action, make sure on that list where you have, you know, gender and sexuality and age and all those other attributes, make sure that you've got family and domestic violence listed there. And also make sure that everyone who's in a management position who may come into this information and be working with anyone who might be experiencing that, just make sure that any decisions that are made about those employees are not adversely made because they've experienced the family and domestic violence. So we know this is not okay, but I guess we're closing the loophole on that. So yeah, I would just say you need to just update your handbooks and your policy manuals for that, and then just make sure all your people managers are aware. But the first change that came through in the legislation is around sham contracting. Now, sham contracting is when you deliberately try and coerce someone to be a contractor rather than an employee, so that they miss out on all the key benefits that an employee gets. So the piece with this one is pretty black and white. It's when you're doing this deliberately. Right, it's a sham contract. Now, not all contractor agreements are obviously sham, but just so you're clear on this. And look at the penalties, man, they're really going hard on this one. Between $939,000 and $4,695,000. So obviously that's where, you know, business has got many of these going on. They're really trying to nip these in the bud. So just to be clear, what we're talking about with a sham contractor, it's where you tell an employee that they're a contractor when really, for all intents and purposes, they're an employee, and maybe they're a vulnerable worker and so they go along with that. You make a false statement to convince an employee to do the same work as an employee but to be classified as a contractor, or you dismiss an employee and then rehire them as an independent contractor to perform the same or substantially the same work. Now, that third point, in practical terms, sometimes does happen. It doesn't necessarily mean it's always going to be a sham contract, because sometimes the nature of the way you engage someone does actually change, and sometimes they're really keen to do that as well. So I wouldn't say you never can do that. Just be very careful that it's well documented, there's a good consultation process, and that, you know, you followed some due process there, so that, you know, nothing becomes an issue. That came into effect in February. And as I said, the action is just, I mean, gosh, I think with all your independent contractors, just make sure you've got, you know, good watertight documentation to support, you know, why they are a contractor. This one's a big one. I mean, you know, it's one that you kind of hope and pray never, ever affects your business. But if it did, it's a big deal. So what many of you might have, particularly those of you that work across different state jurisdictions, the different work health and safety legislation for each state some states have already covered this off. There was already industrial manslaughter legislation. I think Victoria led the way. Yeah, basically it's to bring all the states in line with each other. So this is where we have a preventable work-related death in the workplace. The big case that came out last year, you might have followed this, and unlikely to happen in any of your business, but I guess, you know, your people go on site and there's hazards there. There was a case in Victoria where a forklift crushed a person to death, fell over. It was that safe work practices weren't followed, crushed someone, they died, and the business was fined $1.3 million. I mean, how do you quantify the death of someone? That's kind of always a bit sort of ick to kind of even think along those lines. But I guess the message there is making sure, you know, you've got good work health and safety practices for yourself, and also, you know, that you check those out for the environments that your people go into. I think the other thing here that I'm really conscious of more and more is psychosocial safety hazards. And obviously, you know, where someone might take their own life because of a work-related issue. I think we'll see more and more of those, and this will definitely encapsulate a suicide if that was to be a work-related death. So again, it's this whole idea of preventable, and has the workplace, you know, caused this issue, and could it have been prevented? So it's complex, but it's just important to understand that it's now a federal law, as it should be. Will come into effect on the 1st of July. Now this one, if you've been following the bouncing ball on this one, it'll be fair enough that you'll be sort of going, I just don't get what they're trying to do. So what we had years before, for as long as I can remember, certainly as long as Fair Work has been around, the definition of an employer or a contractor was completely changeable and dependent on the nature of the way that person was engaged. And so there was no rule of thumb. You couldn't sort of say, well, we gave them a contract and they signed it, so they're a contractor or they're an employee. So what happened back in 2022, you may have followed this, there was two huge landmark cases. One, personnel contracting, and Jamsec was the other one. And what happened in both of those cases that went all the way through, I think, to the High Court, because it became a turn of legislation, was that in both those cases, the contractors had independent contractor agreements that the businesses were basically saying, well, these people are independent contractors. And where the legislation landed was, well, if the contract says something, then the contract stands. That's actually going to be what you can follow. So if two parties agree something, regardless of what it might look like over here, you can rely on the contract. So this was huge. And basically it gave us all a lot of confidence that if we're going to enter a contract and everyone's willing and able, and that whatever that contract is, we can rely on. Okay, so that was not popular with the legislators, and what they wanted to do is actually return back to this more substantive testing. And so what we now have is a new definition of what an employer and an employee is, but it gives you no real clarity. We're back to the sort of the muddy waters of before 2022. So what the definition says is we now determine whether someone's an employee by assessing the substance, practical reality, and true nature of the working relationship. I don't know what that means. Do you know what that means? Again, we're going to have to rely on precedent and case law to sort of give us more information on that. But we consider the totality of this relationship and not simply rely on the substance of a contract. So basically reversing the impact that those two cases had and the direction we were going down. So yeah, bouncing ball all over the place, but we're back to where we started, and no more the wiser in terms of, can we absolutely categorically say you're an employee and you're a contractor? It's still very much around, hours of work, the way you engage, tools of trade, all of these things start to, whether they invoice, ABNs, all those kind of things that really don't really get you to an absolute position. This will be effective on the 26th of August, this legislation. So really what I would be doing if I were you, again, if you had any independent contractors or you've got anyone who kind of sits and sort of blurs the lines, just have a good look at what the substance of that relationship is and just make sure it's well documented on both sides. So along with the redefinition of an employee, we also got a new definition of a casual, and almost exactly the same scenario. What we had in 2021 was the Rosato case, which you might remember was the casuals that claimed annual leave, and they won. And it was like, hang on, don't we pay 25% to cover that and not be having to, fork out annual leave and other things when someone leaves? So yes, what we learned in 2021 was we had to be really overt in our casual contracts, that we would spell out that, the 25% was there to cover all of these things, and that, each shift, your employment started and ended with each shift, right? So we've been going along since 2021, understanding that. What we now have is a new definition that, very similar to our employee definition, it's all based on the substance of the relationship. So again, the contract won't save us necessarily, okay? So there's a new piece of legislation which is called 15A, and it basically says that in the absence of a firm advance commitment to continuing an indefinite work, and that the employee is entitled to casual loading. So I think we're fine on the casual loading, we're all okay with that. But there needs to be a clause in your casual contract that basically says this arrangement is all predicated on the fact that there won't be a firm advancement of certainty of work. When we were updating contracts back in 2021, we did insert something like that. I think you probably do have something to those effects. Just make sure it's really clear. And then you can kind of keep proceeding on and you'll be fine. But I think it's definitely looking at that existing casual agreement. Make sure they're truly casual, obviously. And then I'll talk about, the casual conversion in a minute, because that kind of is our sort of catch-all for that as well. So yeah, check your legislation and just look at those casual arrangements. The third area on the independent contractors, so we had the sham contracting, we had the definition of employee. What we now have is independent contractors can now go to the Fair Work Commission to argue their case on whether or not they should be a contractor or an employee. So never before has contractors had any jurisdiction in Fair Work, right? Because obviously they're a contractor, that sits under contract law and it's a whole different environment. So now what you can have is if someone who is a contractor with you and they believe they should be an employee, I mean, these things rarely happen in practice in our kind of businesses, right? But there's lots of businesses where they're forced to be a contractor rather than be employed. They've got no certainty of work. It's a very precarious relationship. They can be, terminated at the end of the contract. So what this loophole is trying to close is where someone has been in that position and now they have an avenue to go down. And I guess the avenue, if you think about it conceptually, is if I should be an employee but I'm being treated as a contractor, shouldn't I still have access to Fair Work? Kind of makes sense when you think about it that way, but it is quite a radical change. And that comes in August. So that's the sort of the trifecta of the loopholes that they're trying to close with independent contractors. As I said, I still think we've got a mess there. And obviously we've got SGC legislation and we've got, the tax office sees contractors in a completely different way. So to make sense of all of that, it's still as hard as it ever was. I don't think we have more clarity in terms of how we make that decision. So again, we've got new casual conversion provisions. I must say, when I first saw this, I thought, surely not. Surely not. We're not going to have to sit down with every casual at the 6-month mark and ask them if they want to convert. Surely that's a ridiculous premise. The thing is, when you look at the fine print, that's not what it's actually saying. It looks a bit like that, but it's not actually what that is. It's still the case that at the 12-month mark, you must do that. You must consider at the 12-month mark with every casual that you have, whether or not there is an opportunity for that person to convert to permanent. You have to, my advice is always to have that overt conversation. Most of the time they probably won't want to. Most of the time they probably aren't a regular and systematic casual anyway, particularly if you've got students working in your business that have, their schedules change with every semester and so forth. But what this is trying to close, I guess, is where you do have someone who really should be a permanent, even if it's a part-time person. But you're treating them as a casual, and again, they've got that precarious employment and it's, you're getting around, I guess, some of those obligations. So what employees can do now, the onus is completely on them, is when they get to the 6-month mark, if they feel that their working arrangements have maybe changed or they are looking more systematic and permanent, they have the opportunity to approach you and ask if they can convert. But the onus is on them. You do not have to do anything at the 6-month mark with a casual. Your spreadsheet should all be working to the 12 months, but if they come to you at the 6-month mark, I guess just be aware that they do have a legal entitlement to ask you, and obviously you have a legal right to say yes or no, based on what your business operations look like.
So can I ask a question there? Is that the point around consideration, you just have to consider it?
You just have to consider it.
So it's just a conversation, you don't have to leave one way or the other?
No. Same with the 12-month. Like it all goes back to, your business operations and why that role would be casual in the first place versus permanent. So there could be a whole lot of reasons why you wouldn't convert someone. I mean, 6 months just seems really quick. I mean, unless it really is clear that it should be a permanent role, right? I mean, 6 months, they could still have worked the same shifts for 6 months, but then the next 6 months are going to change, or, it's project related. So for this project, we're working this way, but, we don't know what's around the corner. I feel like there's many legitimate business reasons why you wouldn't convert. And my experience is very few people want to convert. Most people in the environments we're in, if they're casual, they enjoy the fact that they're getting a higher rate of pay each hour. They don't sort of mind so much that they're not getting the leave. But I guess when that person does come to you and say, I want that job security, I do want to have leave, it is important to me, I think you've really got to take that on balance and look at what are they really doing and, is that a fair thing? So no action on your behalf at the 6-month mark. You don't have to, at first I thought, gosh, we're going to have our probation list, we're going to have our casual list, but no, when you look in the fine print, that's not what this is about, but just have it on your radar. Another one of the big ones, big ticket ones here is the wage theft now is considered a criminal offence. So this is a big scary one, but when you sort of look at what the intent is here in terms of closing loopholes, the intention here is where employers have knowingly underpaid people. Knowingly. So this is what wage theft is. Wage theft isn't, oh my gosh, it's so hard to interpret this award, we're trying our best, we've got sort of overtime policies and we do boots every year to sort of see how we're doing, and we made a mistake. That's not what this is, okay? We know that happens because awards are complex, pay rates are changeable. This is where you know you've got an issue and you're going, we're just going to let sleeping dogs lie there and we're not going to do anything about it. Or we knowingly set pay rates that are too low, okay? So I don't think anyone has an issue with this conceptually because obviously we know it's not good. But when you start to look at the fines and penalties, like they're going hard for this. And we've already seen some large organisations out there who have been stung and huge fines. The fines are all multiples of your underpayment. So the more you underpay, the more your fines are going to be, as well as needing to repay that. So there's a huge deterrent. And imprisonment for up to 10 years. This is the criminality side now. Surely that's going to deter some people. I mean, I don't know what else they could do, right? But basically it's all about that intentional engaging in conduct that results in failure to pay on or before the manager. Thing to remember here, this is all remuneration, so it includes superannuation as well. And, you know, there'll be businesses that'll be caught out with that, you know, that haven't paid their super for a couple of years and, you know, fair enough, they should probably be caught out. So yeah, I've got the fines there for you. Effective date will be January 2025. So it's kind of saying to everyone, get your house in order now because we're going to go hard. What we're seeing, I mean, it's happening with the tax office, it's going to happen with the Fair Work Commission as well. Resources are being redeployed, because of automation, of a whole lot of other things, resources are being redeployed into the audit and the reviews. And so expect to see a lot of activity from 1st of January in this area because resources that were doing compliance and kind of, you know, fairly manual things over here are being redeployed in these departments to actually go actively out, match records back with the ATO, match records with super funds and payments, all the single touch stuff that goes through payroll, and they'll now come after businesses they'll have all the information. So I suspect there'll be a lot of activity in this area. So yeah, look, the thing I would also say is remember this is about intentional. And many businesses, most businesses, it is unintentional. We do a lot of work doing boot calcs for businesses and just doing, particularly where you've got people who are close to the award rates and maybe there's a little bit of overtime they do or maybe there's a lot of overtime they do. That's your worry area. You want to make sure that your overtime policies, your time in lieu policies will cover your better off overall test. So if you have any concerns in that area, I think that's where I would be focusing most of my effort in terms of these legislation changes because I think particularly in architecture, it's such a difficult award and the nature of the way we work and the rates of pay, particularly for our graduates and our sort of more junior people, they're always kind of not too far off the line ball there with the award. The award's going up on the 1st of July by 3.75%. That's the increase in the national minimum wage that will flow on through the award. So I think in the next few weeks, that's what I would be looking at if I were you. Just make sure you've got a buffer zone there. And yeah, don't underpay your people and you won't have to worry about going to prison. Just watch the other businesses go on the front page of the Telegraph, you know. Look, there's a whole lot of things that, as I said to you, I don't believe affect you. I just want to talk top line through these, but I'm not going to go into any kind of detail. But stop me and ask me questions if you want to know more. You can see there's a whole lot of things that involve the rights of a workplace delegate. So a workplace delegate, for those of you who've never sort of come across one, is where you've got a unionised workforce and there's nominated delegates who represent the workforce, you know, alongside the union. what we're getting through the legislation is loopholes being closed in terms of their rights, their obligations, what they're able to do, the position, how they're treated in the workplace. Typically not the most popular people in the business from the business owner's perspective. And so, there's just some tightening of legislation there. That's where the compulsory conciliation conferences, it's quite a technical change there. You would have maybe seen stuff in the news about this, and it's sort of, unless you're really involved in enterprise agreements, it probably doesn't make a lot of sense, but there's now the ability to have multiple enterprise agreements, so businesses coming together under the one enterprise agreement. I don't know why you would want to do that. I really don't. I'm on the board of a hospital, and they were approached by a whole lot of other hospitals to see if they wanted to go into multiple enterprise agreements, and they said a hard no, because they're hard enough to navigate within your own jurisdiction, let alone having to take into account a much broader audience. But I don't really work in that space, so I'm sure there are benefits to it. I just don't know what they are, and I can't understand what they would be. So more on the delegates' rights terms. A lot of these things will flow through to the Architects Award. So if you're kind of like me and a bit nerdy with your award, and you like to read through all the changes, what you will see is these workplace delegate changes in the award. I suspect you probably don't have to worry too much about it, but I mean, just know that they're there, I guess. Then there's a whole big piece of legislation around the gig economy. So our Uber drivers, those people that are hired for piecemeal work. Again, I suspect you probably don't have anyone like that in your workplace, but for those workplaces, there's really quite dramatic changes, just to kind of, I guess, regulate what a worker means under those environments, which when you kind of step out, and particularly as an HR person, you kind of look at what the conditions are, it's kind of, there's a bit dubious, some of the practices that go on there. So I think it's just, tightening a lot of that up. So your Uber driver hopefully gets a better deal. And then there's, some model terms for enterprise agreements, which is basically to try and standardise, because historically they've been pretty, when they were first sort of started to be introduced, that it was I think the lawyers had the most fun of everyone designing enterprise agreements and coming up with really like quirky, clauses that no one in the business ever understood. And so businesses have been caught out for the last 14 years with weird clauses in their enterprise agreements. So what we've got now is a little bit of standardisation of what should be in there. But again, I think it's probably not likely to affect you. But yeah, as I said, you might see some of that come through in the award. So I thought I'd spend a bit more time on right to disconnect. This was the last minute addition, the deal that was made with the Greens to get closing loopholes across the line, so we are told. I wasn't sitting there in Parliament, so that's just anecdotally what I've heard. But we certainly didn't anticipate this. It wasn't something that was talked about for months beforehand or released in any kind of draft form for us to digest, like everything else was. So when it happened, it was pretty sensational. Certainly in my world, it felt pretty sensational in terms of people's response to it, because what it sounded like was you can't contact anyone in your team before or after hours. And we heard about Belgium and France and Germany and Europe and all the, how that's been working in those countries. And we were like, what does this mean? And so what I want to do is just talk you through what it actually means, because I think we've got a better understanding. And then what to do, because I think it is a huge opportunity to get really clear on what your culture is and what you can do around this area. So, right to disconnect. An employee may refuse to monitor, read or respond to contact or attempted contact from the employer or a third party, so clients, outside their working hours unless the refusal is reasonable. So that's the key phrase, I guess, is unless it's unreasonable. So I'll talk to you about what that could look like. So when we talk about contact, obviously we go to emails, we go to texts, phone calls, any knocking on their door, anything like that. I'm sure it happens in some places. So that's what it is. It's that the employer has the right to refuse that. So a couple of things there too, outside their working hours is probably a key point as well. What are their working hours? How much control have we got over third parties? we can control what we do, but we're obviously interacting with a broader range of people. So that's the first part. The employer, on the basis of that, the employer may not instigate any negative consequences following such a refusal. So now we start to see where this is actually going. Like, first of all, we say, the employee can refuse, and so we think, oh, okay, so we can't do that. Well, actually, we can. We can make contact with them outside hours. It's just that the employee cannot respond. They have the right to not respond. And we, as a result of that, can't take adverse action against them. That's really what this is about. This sits in general protections, adverse action. So the bouncing ball's got to go a few steps along the way before we really have an issue. Okay? So essentially the purpose of the legislation is to further the work-life balance and mental health and well-being of employees by effectively limiting the excessive intrusion of work into personal time. I think we all think that's a good thing, right? But what does that really mean? And obviously for different businesses, this is going to mean very different things. So two entry points for this. For most businesses, it's going to be the 26th of August this year. And if you are under 15 employees, it comes into effect in 12 months' time. So let's talk about what unreasonable contact looks like and what reasonable contact looks like. So what we know from the commentary that's come through is whether it's unreasonable will depend on a whole lot of circumstances. So the reason for the contact. Our retail clients are saying, well, we have people who work shifts, and if someone's sick, we have to call them that night to see if they can show up to open the store. Are we allowed to do that? Yes, that would be considered reasonable. Obviously, this is part of their onboarding. They understand that this is the way you communicate around rostering and so forth. They sign a contract that agrees that, they understand what their work is going to be. That would be considered reasonable. Similarly, a super urgent issue has arisen, and absolutely there's only that person who can answer that question for you. You have a right to reach out to them. Okay. So the way that the contact is made and the level of disruption it causes. So 16 phone calls at 11 o'clock at night will be considered unreasonable by pretty much anyone, okay? So, making sure that, when you do make that contact, that it's done in a reasonable way, knocking on their door. The extent to which an employee's remuneration compensates them to remain available outside their ordinary hours of work. So, this basically means for, the high flyers, they're pretty much available as much as they ever were. You start looking at this and you start thinking, did we really need this legislation? Don't we already have a whole lot of other things in place? Doesn't a boot test tell us that we can't expect somebody to do something after hours without giving them some kind of overtime or time in lieu? There's a reasonableness that actually sits in other areas, and this is kind of, shining a light on this particular issue. But my personal view is this was redundant legislation. We had other legislation that actually took care of these issues. So yes, the remuneration, can be compensated. So this is where I want to talk about in your employment agreements where you've got the clause, this is what your pay is for hours 8:30 to 5, and this includes reasonable additional hours. What I would recommend is you look at that clause and you clarify what reasonable additional hours might mean in the context of your business. If that means that, and I would highly recommend you use the words including being available to be contacted, if that's something that's going to happen, okay? Particularly if the remuneration is on the higher side and you've got, a bit of a buffer there. But the things I'm kind of including in most clauses now is, be available to attend meetings, to meet deadlines, and to be available when needed. Those kind of things. So it kind of goes more than just reasonable additional hours, because I think that's where the challenge. We were expecting, by the way, just for the HR nerds like me, we were thinking we'd actually get a different definition of what reasonable additional hours was. And we were running a little wager in my office of what that would be. I was going for 45. I thought that they'd actually prescribe this and there'd be a rule of thumb. It makes sense that they didn't. But there was a lot of talk about that. And it was kind of interesting that what they've landed on is, that there's some boundaries to it. It depends on the nature of the employer's role and the level of responsibility. By and large, when you're interviewing someone and you're describing the role and you're talking about what's going to be expected in terms of the role, that's the time to talk about it. Then you give them the contract and they sign it. Their position description will probably be, fairly elaborate. You have a good policy where your time in lieu and your overtime policy covers what is reasonable additional hours and what sits in overtime. It just kind of makes us be a lot more transparent around what that all means, for the relativity of our business and for the relativity of roles as well. And then we've got their personal circumstances, and the commentary said including family or caring responsibilities, which, I think we understand that that's important. I would ignore that statement and say everyone kind of deserves to be treated the same in this area, I'd say. I wouldn't necessarily say, I won't contact them because they're feeding their family for dinner when the other person is actually going to the gym. I think we've got to kind of maybe take a bit of that qualifying judgy stuff off it. But anyway, this is how it came out. So just so that, I guess it's an example. Any questions on that? We'll have question time as well. But I think that this is what can you do? What does this really mean? And it's all relative, yeah? So a few little myth busters. So right to disconnect does not stop employers from contacting employees outside of work hours. It doesn't. We thought it might, but it doesn't. It means you still can make that contact. What I would say is, when we think of the legislation that was passed last year on psychosocial safety, this sits more there than in any other part of the legislation. If we've got people who are being burnt out because they're being, they wake up in the morning and they've got 17 emails from us, or worse, we've sent 17 emails at night before they go to bed and they can't sleep because they're now worried about, what they've got. That is psychosocial safety. That's not this. That's actually all the issues we have around WHS. So there's reasons to not do that sit in psychosocial safety for me. So if you're looking at that and you're looking at the culture of your business and the kind of, how you're wanting to, I guess, identify and manage your risk in that area, I'd be looking at it through that lens. Yeah. Sorry, I've done this so small I can barely read. Does form what? It's a protected attribute. So this is where it lands. So again, like all of our other protected attributes, we now have this protected attribute that someone has a right to not respond to contact that you make. So how we then act towards them if they don't is really critical. That's actually where the problem may or may not be, is if we then take disciplinary action against them or treat them in a detrimental manner as a result of them deciding that they're going to have pretty clear boundaries around what their work life looks like, and we treat them differently. They don't get promotions, they don't get access to training, they don't get remunerated the same as others. We've got to be really careful around those kind of decisions in light of us saying, well, they never answer their emails, and when I call them at night, they don't answer, and so yeah, no pay rise for them. I mean, that's where the rubber will hit the road with this, is if there's a clear delineation there between those decisions. So I think the greater concern is definitely around whether it's a psychosocial hazard has been created, and that would be the business's primary focus. So cover off your risk there, and I don't think you'll really have to worry about getting a general protections claim against a right to disconnect, because you'll actually be looking at it through a different lens. Yeah? What happens if there's a dispute? So obviously, like all disputes, you want to try and solve it internally. Kind of, if you believe that it is reasonable contact and that they're actually not responding to what you consider reasonable, you obviously got to deal with that appropriately, the same way that you deal with any other performance issue or a workplace issue. If you can't resolve that, the employee may go to Fair Work and ask for Fair Work to come in and look at this situation and make an assessment of it. What we know about the stop orders, we have them for bullying, we have them now for sexual harassment, we have them now for right to disconnect. Pretty ineffective. Most employees won't go down that avenue because there's kind of nothing in it for them. It's like stop, or I'll say stop again kind of thing. Most, if they're really aggrieved, will be looking for some kind of compensation or some other avenue to follow. I think this sits in WHS. It's a workers' comp claim more than a Fair Work claim, but just so that you know, this is a process that they could go through. Breaching the Fair Work Commission could put a stop order and say you can't be doing that, and obviously then there's penalties if you breach that, And obviously then, employees can make this general protections claim, and that's what they would be more likely to do. And of course, we all know employees don't have to resign and leave to make a general protections claim. They can still be in your business making a general protections claim, and that's a pretty hectic thing when it happens. But, I guess, remember we're closing loopholes here, and so for those workplaces where this is an inherent issue and it's toxic and it is creating burnout, you can see that, what they're attempting to do is really close that. And I think conceptually and culturally these are good ideas. It's just not to get too nervous about it, I guess. Yes, I can send that email. We're not going to end up in court because of that. So let's talk about what does it mean practically. That's all the background, I guess, of what it means legally. What I think this actually means, and the opportunity we have, is we've already got our obligations on psychosocial safety, as I said, so it does, align to that. I think it gives us a really good opportunity as a business that wants to have a good culture, that stands for a whole series of values, is to align it. Align this thinking to the kind of business that we want to run. So really look at the expectations around hours, whether that's the hours that your clients expect of your people and the access that they're expecting, and what internally is being expected around communication, making sure compensation is adequately considered. I think that's the key here, and it always was. If someone has to do more outside their hours, are they being adequately compensated for that? So that gets back to our boots and all those other things that we've already had in place. We know this already. And then looking at how we update our work practices, policies, and how we train our managers, our people leaders, to be aware of this legislation so they don't inadvertently breach it. Because probably it will be an inadvertent breach for someone who didn't really understand what the legislation means or what the policies mean. And so there's an education piece there, I think, too. I think it's a really great opportunity to embrace technology and use as much technology as you can to actually, create some really great protocols around what are our core hours, what are our extended hours, how do we communicate with each other, on what circumstances would we go outside of those hours. I don't think they're hard things to do once you kind of put your heads together and work out what that means for your business. We've done it for our business. We basically have a flexing day where you can start from 7:30 and work till 6, but your core hours are 8:30 to 5. And so what we've agreed collectively is that's the time when you can communicate and you should respond. So between 7:30 and 6, because people will be flexing. So they might send an email and they get in at 7:30, and that's okay to get that. And if you're working at 6 o'clock, that's okay too. Outside of that, it's really circumstantial. So if there's an urgency, if there's something going on, if there's something else. So what we're using is schedule send. We use Outlook, and so you can schedule send. So you can schedule send between 7:30 and 6. So if you are someone who does park a whole lot of work to nighttime, rather than sending messages, I work these hours, but I don't expect you to, don't do that. My advice is don't do that, just schedule send. Yes, they might get like 17 emails at 7:30 in the morning as I keep apologising to my team. But I mean, we've agreed this. These are the protocols we've agreed. We've talked about it. We're really transparent around it. That's what works for us. You work out what works for you. And know that, yes, there will be things that sit outside of that, and everyone understands that that's going to be only when necessary. So yeah, I think there's some opportunity to kind of get really clear on what that is. And I don't think you have to be I don't think you need to say 8:30 to 5. I think you can be broader, as long as you've got your boot done and everyone's getting paid enough. But yeah, they're kind of the main things that I wanted to take you through. Excellent. Thank you so much, Good. No, my pleasure. Nice to see you all. Thank you.